Hi, this is Stuart Talley here. I'm the partner responsible for the Stryker Rejuvenate litigation. Doing this video today to provide an update on the status of the litigation. I just got back from Minneapolis yesterday where we had a hearing on the case before Judge Frank. And this is a hearing that he has every month to get an update on the status of the litigation, how things are progressing, and to really sort of keep things moving forward so that the case doesn't delay or drag on. The first thing we talked about at the hearing was the judge wanted an update on the status of the cases, how many cases were filed, what's going on with them. And the report to the judge was that there are about 1,500 cases that have now been filed around the country. Many are in state courts in various jurisdictions. Most are in the federal court system before Judge Frank. What Judge Frank has been doing as the presiding judge is he has been reaching out to state court judges in these other jurisdictions to talk with them about the case, in an effort to coordinate the cases so that the same thing is not going on in different courts, or the parties aren't being subjected to conflicting orders on various issues. So there is an effort on the part of Judge Frank to coordinate the cases. The second thing that was brought up, which is probably the most significant issue that many people are wondering about, is settlement. And in large mass torts like this, settlement is usually very difficult to achieve on a large global basis, and that's typically the only way these cases get resolved. So what's been happening is Stryker has shown some interest in resolving cases, and they've started a settlement program in New Jersey where they've basically been mediating individual cases before retired judges, who are what we call mediators, and have actually been able to resolve some of those cases. What we were told yesterday is that out of 10 cases that went to mediation, 9 were resolved. The big problem with this process is that it's really not a global process. It's not a process that can be used to resolve thousands of cases. Resolving 9 out of 1,500 cases doesn't help much. So what Judge Frank indicated was that he was going to be sending his magistrate, Judge Noel, and that's a magistrate is a judge that's not appointed by the president, but they're actually hired to assist federal court judges in federal courts. And so the magistrate is, in this case, is being used to assist Judge Frank. He's flying to New Jersey this week or next week to meet with the mediators, to talk with them about how these cases are mediating, how they've progressed, and to come up with ideas on how some kind of global mediation process could be approached. The parties are also talking about that in some context, and hopefully there'll be some type of resolution fairly soon. The big problem, which sort of leads to the next issue, is the issue of discovery. At this point, very little discovery has been done. Stryker has produced some documents, but it's not even close to the number of documents we would expect in the case. Right now we're at about 80,000. In other HIP litigations, we usually receive between 7 and 8 million pages of documents. So there's a long way to go. And what we expect is that there is information in those documents and information that will be obtained through depositions that will be very good for the plaintiffs. And that is a reason why Stryker is rejecting efforts to produce documents. And in the parlance of lawyers, we call it they're slow playing the game. They're coming up with reasons to delay productions. And the goal is that they want to push all of these cases into settlement mode before they have to produce any damaging documents or provide any damaging testimony. So at the hearing yesterday, there was a lot of discussion about Stryker's refusal to participate in discovery, refusal to produce documents. Obviously, Stryker disagrees with that characterization, but that was brought up and discussed in great detail. Judge Frank, who moved very quickly on these issues, wanted briefing and the issues to be brought to Magistrate Noel to decide and be raised at the next status conference. So we are sort of operating on two tracks. On one track, we are trying to push the discovery, trying to push Stryker to produce documents and people for depositions. And on the other track, we're exploring the possibility of some kind of global resolution, which Stryker seems eager to do. So that's where the case is right now. It's progressing, not as quickly as we would like, but it looks like there is some light at the end of the tunnel, and hopefully we'll have some progress, more progress to report at the next status conference. That conference is set